Good morning, friends. Let us dive into another question of paper 1 of 2019 Advocate on Record. The question is, on what grounds can a recusal application praying for recusal by a judge be filed by a party to the litigation in the Honorable Supreme Court of India? Friends, a recusal application seeking for recusal of a judge in the Supreme Court of India can be filed by a party to the litigation on several legal and ethical grounds. However, such application must be made sparingly and with due seriousness, as they touch upon judicial integrity and the right to fair trial. So let us first discuss grounds for seeking recusal of a judge in Supreme Court. Bias or apparent bias, mean to say real or perceived. If a judge has a personal interest in the outcome of the case, if there exists a reasonable apprehension of bias in the mind of a fair-minded and informed observer. Now, let us go into types of bias. It can be pecuniary bias, that is financial interest. It can be personal bias, such as relationship with the parties or lawyers, or it can be due to subject matter bias, prejudiced views or opinions expressed previously. Second ground can be conflict of interest. If a judge or their close relative or associate have any direct or indirect connection with the matter or with the litigating parties. Third ground can be previous involvement in the matter. If a judge has previously acted as a counsel, arbitrator, amicus curiae, or has adjudicated the matter in a lower court or tribunal. Then comes the ground of prejudicial public statements or remarks. If a judge has made public comments, opinions, or remarks indicating prejudicial judgment of the issues involved. Then comes the ground of previous adverse orders or expression. When a judge has expressed views in the earlier orders or during hearings that may suggest a closed mind or bias. Now, legal basis and judicial principles. The doctrine of nemo judex in causa mean to say no one should be judged in their own cause. Article 14 and 21 of the Constitution of India ensure equality before law and fair trial. Now, let me explain or quote one or two Supreme Court precedents. In state of West Bengal versus Sivananda Pathak, that is of 1998, it was said that bias must be reasonable and not imaginary. And in Ranjit Thakur versus Union of India, this case is of 1987, it was held that the test is whether there is reasonable apprehension in the mind of party. Now, procedure and considerations. Application must be in writing, stating the precise grounds and material facts. It is decided by the judge concerned. The recusal decision lies solely with the conscience of the judge. There is no appeal or judicial review of a judge's decision not to recuse unless in rare cases involving constitutional challenges. Sometimes, friends, there is abuse of recusal applications. The Honorable Supreme Court has warned against misuse of recusal requests to bench shop or delayed proceedings. Frivolous or speculative applications are discouraged and may attract costs or contempt of court. This is all about in this short video. Thanks for watching. God bless you all.